Hello. Hi, everybody. How's everyone doing today? It went from summer to I don't know what it is out there again. I know we do. We don't have to water the plants. So today we have a lot of interest in this program. This is a special program from the Judicial Speakers Bureau, and we have Justice Paul Wilson here, who's going to be talking to us about laws and government and the rule of law in America. Okay, yeah. So go easy on him. Just a reminder, Walpole Media is filming today. So as always, if you have a question, if you could just raise your hand and either Paul will repeat the question or bring the microphone over to you so we can hear it on film. Thank you.
Good afternoon. My name is Paul Wilson. As you heard, I'm a Superior Court judge. I have the honor of serving you all and your fellow citizens of this Commonwealth for the last 9 years as a Superior Court judge. The Superior Court is the higher of the two levels of the trial court. Trial courts are where cases start. If somebody sues somebody, it's in the Superior Court, or if less than $50,000 is involved, in the lower court, the district court. If someone is prosecuted for a crime and it's a felony, it starts in the Superior Court, or misdemeanor in the lower court, the district court. And so we resolve cases either by convincing the parties to settle their own differences, or on the criminal side, do a plea bargain, which we have to approve because only a judge can sentence someone. And if that doesn't happen, we do pretrial proceedings, which might get rid of a case because it was filed too late, so we dismiss it, or the facts are so clear that we don't need a jury to decide them and somebody wins. But if none of that happens, then it goes to trial, usually in front of a jury, sometimes just a judge. And that's what we do in the trial courts. And then if someone is unhappy with that decision, then there's two levels of appellate courts above us, the appeals court and the Supreme Judicial Court. And so that's how the court system is designed. The Superior Court, on which I serve, has about 80 judges statewide. We ride circuit, we call it. That is, we move to a different courthouse or a different side of the courthouse we're in, criminal versus civil, every 3 or 6 months. We do that partly because we've been doing that, I gather, since 1859 when the Superior Court was established. And every so often somebody would have to get on a horse in Boston and go out to Worcester and do some justice, or come to Walpole and do some justice. I don't know. So we still do it. I just got to ride circuit in a ferry boat because I spent the last 2 weeks as the Superior Court judge on Nantucket. Yeah, I'm finally senior enough to get that kind of assignment. We only send a Superior Court judge to Nantucket twice a year for 2 weeks because that's all the business they have for us, and they work me pretty hard. Anyway, I've been doing this for, as I said, 9 years. I was a law firm lawyer before that, general civil litigator, all kinds of civil lawsuits. And then as I got more senior and more expensive, I had to specialize. Because, when you start charging the higher rates, people expect you to be an expert on something or other. So I became an expert on real estate litigation, fights about contracts to buy or sell real estate, fights about what could be built on the real estate once you'd bought it, environmental disputes, things like that. And then 9 years ago, I became a judge. I'm here today to talk about, I think we titled it, The Rule of Law, and how the judiciary makes sure that America is governed by the rule of law. One of the most important tasks we have as judges, I'm convinced that a lot of us think, is to go out into the community, take off the robe, put on the suit jacket, and go to places to meet people like you, to tell you about how this country really is governed by the rule of law, what a great thing that is, and how the judiciary plays into that. So my format, I'm going to do a short presentation, but I really like it to be more a conversation than a lecture, so please feel free to stop me and ask me questions anytime you want. And at the end, I'm going to allow plenty of time for questions about not just what I'm talking about today, but anything you have to want to know about concerning the court system or being a judge or any of that stuff. Let me talk first about what we mean by the rule of law. Consider Walpole, Massachusetts, 1770. We were governed, Walpole, Massachusetts, the 13 colonies were under the rule of man. That man's name, as you know, was George III, the King of England. And what he said and his parliament said went, period. A lot of people in Walpole and Boston and the other 13 colonies were not happy with the way things were going, but they couldn't do much about it because there was a king. It was the rule of man. A lot of countries work that way to this very day, as you know. If you've been watching the news, you know Russia is one of those countries where there's a rule of man and not the rule of law, and certainly not the only one. So the American colonists are feeling oppressed. One of your neighbors in Braintree, a man named John Adams, says in 1744, what we need is we need a government of laws, not of men. Let's see if we can work on that. That was 1774. That was his words. And Americans, colonists did work on that. They turned out not to be colonists. A decade later, they had their own country. And so Adams and others in Massachusetts first adopted a state constitution that was, in fact, the first way in which laws started to govern here and not men. An American Constitution followed, which was based in large part on John Adams' state constitution here in Massachusetts. The key idea here is that there is going to be law. It's going to apply to everybody equally, and not a rule of a king or somebody else, dictator of some other sort. So where does the law come from? Little civics lesson, brief. Three places, essentially. There are three branches of the American government, as you know. There is a legislative branch, an executive branch, and a judicial branch. But above all of those, we start off with a constitution, which is a sort of a set of general principles by which we have chosen to get together in 1787, 1789 to govern ourselves. We've amended it along the way. But those are sort of the core principles, really in broad terms. That's the most basic law. But then there is an a legislative branch that passes statutes, which give more body, more specifics to those general principles in the Constitution. The legislature in Washington is called the Congress. We have one here in Beacon Hill that does state statutes. And then there's administrative agencies in the executive branch, which turn those statutes into much more specific requirements or benefits or whatever. If, for instance, in the Nixon administration, Congress said we shall enact a statute called the Clean Water Act, and another one called the Clean Air Act. And they said in basic terms, we should have clean air and clean water. How are we going to do that? They created an executive branch department called the Environmental Protection Agency. And what does the EPA do? It issues even more specific laws about the things it's supposed to govern. That is, if the Clean Water Act says thou shalt not pollute the Charles River, and not much more than that, then the EPA comes in and passes regulations that say, well, here's the kind of stuff you can't put into the Charles River. This stuff is okay, but that stuff's toxic, so don't put it in, and you break the law if you dump that stuff in the Charles River. So that's sort of the three levels of law, from the general Constitution to the more specific statutes to the really specific regulations. And we've covered two branches of government now, right? The legislature, which does the statutes, and now the executive branch, the administrative agencies like EPA, the Internal Revenue Service, you name it, which then does these very, very specific regulations. There is the third branch of the government, my branch, the judiciary, which isn't really in the business of making law. We don't set out to make law, I should say, because what courts are supposed to do is resolve disputes between specific people who show up in their courtroom because one sued the other, or because the government says this person committed a crime. We'd like to try him and send him to jail. So the court's job is really to resolve that dispute between one person or two people or the government and one criminal defendant. But in the course of doing that, the courts end up doing things that make law. Here's an example. Mr. Miranda in Arizona, 1960-something, gets arrested, he says, coerced into confessing to a crime. And he goes to a judge and says, hey, wait a minute, they can't use that confession against me because they violated my Fifth Amendment right. They didn't tell me I had a right to remain silent. They didn't tell me I could have a lawyer, none of that. And so, judge, throw the confession out, and without my confession, they don't have enough to convict me. And so the judge is now faced with Mr. Miranda on the one side saying this, and the government on the other side arguing the other side of it. It's just those two parties. And that judge in Arizona has to decide, well, did this government, did that detective, those police officers violate Mr. Miranda's constitutional right to remain silent by not telling him about it and not telling him he could have a lawyer? And that judge in Arizona said, yeah, we're going to throw that confession out. They can't use it at trial. The jury's never going to hear about it. And the government, now it's the government, right? But it's just lost a case, which, by the way, would not happen under the rule of man. And I'll get to that in a few minutes, right? And so, but the government has a right to appeal. So they go to a higher court and they lose again. And they go to the U.S. Supreme Court, the highest court of all. And they say, the Constitution doesn't require this. The detective didn't have to tell Mr. Miranda about these rights. And the U.S. Supreme Court says, well, I think Mr. Miranda's right. Yes, Mr. Miranda's confession is out. And so now the U.S. Supreme Court, the highest court in the land, has decided a dispute between two people, a federal prosecutor or state prosecutor, whatever, and Mr. Miranda. And that's all they've done. So how does that make law? Because now you've got the Supreme Court saying that Mr. Miranda was entitled to be told about his right to remain silent. So what happens in Massachusetts or Tennessee or Oregon next time somebody is arrested and isn't told about his right to remain silent? Everyone sees the handwriting on the wall and says, well, if the Supreme Court said that for Mr. Miranda, they're going to say it for everybody, right? And so all of a sudden, all across America, police are telling people you have a right to remain silent. So we've made that, the Supreme Court has made that law in the course of deciding that two-person dispute, basically. And so that's how we make law, although we don't set out to do it. The role of the courts really is to apply the law, the Constitution, the statutes, the regulations, to those specific disputes before us. And our job is to make sure that we're applying the rule of law and not the rule of man, as in King George III or Vladimir Putin today. Now that's a big responsibility. And how do we do that? How do we make sure that we're a nation governed by laws and not by men, as John Adams said in 1774? Well, it means, for one thing, we can't favor anybody at all. Everyone is equal in a courtroom. The rich and famous don't get off because they're rich and famous. And we just saw that, didn't we, with the Varsity Blues prosecution. The federal government says, a prosecutor said, these people, rich and famous though they are, have violated the law. They've committed fraud. They've committed bribery. They've committed federal crimes. Some of them are heads of hedge funds, right? These are rich people. One of them is the managing partner of a big New York City law firm, for crying out loud. Some of them are actresses whose names we all know, right? And so are those the sort of people, can they come in and say, wait a minute, I'm rich or I'm famous or I'm whatever, you can't do this to me? No, because the judge has got to say, I'm going to treat you just like you were this lady in the front row here, or me, you've never bribed anybody's way into college, have you? Okay, I thought pretty much, I was pretty sure of that. But if you had, and you were prosecuted, they'd be prosecuted just like you. And that's the rule of law. It applies to everybody. And not just the rich and famous, by the way. It applies to public office holders, to government officials. It applies to the President of the United States. We learned last year when he says, his people go to various courts and say, throw out this election. It was rigged. And what do the courts do? They don't say, well, you're the President of the United States. Of course, whatever you want, we'll do. We're going to toss out these. Michigan goes for Trump. Pennsylvania goes for Trump. The courts didn't do that. They said what they should say. They said, you're entitled to be here. The rule of law says if you can prove that election was rigged, of course, we'll throw out the results. We'll flip Michigan to the Trump column or wherever. But you got to bring us some proof. That's how, because the law requires proof. Yes, sir.
Let's go back to the Supreme Court making a decision.
Yeah.
We have Roe versus Wade.
Aha.
At the moment, but in principle, I recognize you can review things.
Mm-hmm.
But isn't the judiciary influenced by the society
Yes,
itself?
it is.
So that if 50 years ago when Roe versus Wade came to pass, I guess the society was in favor of abortion because it became illegal.
Mm-hmm.
And according to surveys that I've seen recently, 65 to 70% of those surveyed said they were in favor of abortion
Yeah.
Not necessarily that case, but the whole.
I wondered how long it would be before we got to Roe versus Wade, right? Let me tell you first about Brown versus Board of Education. 1954, parents of kids in Topeka, Kansas, go to the Supreme Court and say, our kids are in segregated schools. They're getting the short end of the stick because these schools aren't very good. All the white kids are going to the good schools, right? That's not right. And the Supreme Court says in 1954, yeah, we agree with you. That's not right. The rule of law requires everyone to be treated equally. But to do that, the Supreme Court had to think about a case that was then 50 or 60 years old called Plessy versus Ferguson, where the Supreme Court had ruled in the 1890s that separate but equal is okay when it comes to cars on railroad trains. And so they had to revisit the Constitution and consider how society had evolved, what people were thinking, what was fair in 1896 in all the Jim Crow era might have looked fair to a Supreme Court, but 50 or 60 years later, well, we're going to reassess that. And that's what's happening with Roe v. Wade. The Supreme Court decided 50 years ago that there is this right to an abortion. It's not mentioned in the Constitution, of course. It is found, the Supreme Court said in Roe, in the penumbra, they called it, the sort of the halo of lots of constitutional rights. The right to be free from having cops come into your house and seize your papers, the right to not have a surgery performed on you against your will. A lot of that sort of stuff is in the Constitution, or the Constitution directly applies. And the Supreme Court said in 1973, I guess it was, in Roe, within that whole, we think that this is like that. Abortion is like that, and so we're going to find that the Constitution allows it. Now the court is revisiting it. I'm not sure it's because that the society has changed its thinking on that, because the survey you cite, it is true that most Americans favor abortion rights, but the court's job is to figure out, can we find that in the Constitution? Most Americans might favor the right to drive without seatbelts or the right to smoke marijuana as you drive, right? But the court has to decide, is that legal under the statutes that govern driving or govern the use of marijuana? So they're revisiting it, and it's got to be one of the more interesting things for a Supreme Court justice to do, because they've got to think through Roe and say, why is the world different now? And I have not read the draft opinion because it's only a draft opinion, but I want to see what it says eventually. Yes, ma'am.
I've had some experience with the Fourth Amendment, so maybe you could explain how Roe v. Wade is part of the Fourth Amendment.
Well, tell me about the Fourth Amendment. I don't want to hear about your experience. I said, tell me about the Fourth Amendment, but I don't want to pry. So there are these amendments in the Constitution. The Fourth Amendment protects you against searches and seizures. Back when there was the rule of man, King George sent people into colonist homes to live, for crying out loud, and there was a thing called a general warrant where he could send troops in America, police, whatever the police equivalent was in England, could go into your home and look through your papers and whatever else was there. And that, when the Fourth Amendment was adopted, it was a recognition that we want a law here that says the government can't do that. The government can't just stick a soldier in your house and say, feed him and let him sleep here. It can't come into your house and just look through your papers or now your cell phone without good reason, probable cause we call it. And so that's one of the places where the Supreme Court in the Roe case said that sort of idea of personal privacy from government intervention is the sort of thing that makes us think that a statute that says you can't have an abortion is wrong. It's not the law, the Constitution would overrule that. Now they're kind of thinking about whether that should be true. On the Fourth Amendment itself, the invasion of your house, the courts are now revisiting no-knock warrants, for instance. Sometimes often I'm asked to do search warrants, to authorize a search warrant. A police officer has to come to me and swear under oath, sometimes in 300 pages of history of the investigation, that he or she has probable cause to believe that if I go to this house and search this computer, I'll find evidence of that crime. And here's why I think it's true. And if I think that police officer has shown probable cause, I'll issue a search warrant. And on the bottom, there are some questions. Can we do this at night? Because, that's a greater intrusion into somebody's life. Can we go in without knocking? Now, I almost always say no to that. Most judges in Massachusetts and maybe America almost always say no to that. But sometimes you say yes. And now we've seen that that can result in innocent people getting killed by police officers. And so now there's a lot of thought about whether we should read the Fourth Amendment to say no-knock warrants are ever okay. They would violate the Constitution. And we'll see how that turns out. But that's how the Fourth Amendment that's a hot Fourth Amendment issue these days. And with good reason, because we've seen people get shot who are not even the targets. The cops knock. They don't knock. They burst in the wrong door. So that's the Fourth Amendment issue of the day. So I said we can't favor the rich and famous. We can't favor the President of the United States or any other elected official. Those judges, by the way, and this gave me great faith in the judiciary. There were how many judges across America who said to the Trump lawyers, come in, bring us some proof. And if you bring us some proof, we'll consider doing what you want us to do. And they didn't see the proof. And so a lot of judges all across America, elected judges, appointed judges, federal judges, state judges, appointed judges by Obama, appointed judges by George Bush, appointed judges by Trump. They all said, we're going to apply the rule of law even though you're the president. And you haven't showed us any evidence. If you come in with some evidence, of course, we'll do for you what we would do for anybody else. Look at your evidence and decide your case. With no evidence, we're deciding the case against you. And I thought that was remarkable, that all those judges were committed to the rule of law, that the President of the United States, we can say no to the President of the United States. Let me talk about two of the basic heartland principles of the rule of law that really help us apply it. One is equal protection, and I started to talk about that a minute ago with Brown versus Board of Education. The other is due process. If you're going to be governed by the rule of law, first of all, everyone's got to be treated the same. And segregation in the Topeka, Kansas public schools in the 1950s was treating people differently. Said this group of parents, Mr. and Mrs. Brown and some other parents, they went out, they found a lawyer, they said, this is wrong, our kids are going to these inferior schools. And they can't go to the white school, and that's wrong. And so they went to a judge in Kansas, in Topeka, I guess, and brought their case to him. And the judge, well, before we get to what the judge did, think about, they're suing the government, right? It's the school board, the Board of Education of Topeka, Kansas. They're suing the government, and in many countries, if you sued the government, what would happen to you? The government would say to your boss, fire Mr. Brown. He's a troublemaker, fire him. Or worse yet, kill him. We just passed, I heard on the news today on the way to work, that Mexico just passed the 100,000 mark in people who have disappeared. And a lot of that is, some of it's drug gangs, but some of it's the government, right? Likely, allegedly the government, I don't know, I haven't been there, but you suspect part of that's the government disappearing people. We know the Russians have been sending people to Siberia for challenging the government since Tsarist times, right? And probably still are. That can happen to you if you're governed by the rule of man. But Mr. and Mrs. Brown didn't get fired or shot or sent to Siberia. They hired a lawyer. And by the way, one of the lawyers, the same thing had happened to lawyers and does happen to lawyers in other countries. When Mr. Erdogan decided to declare himself the dictator of Turkey not so long ago, the first people he jailed were journalists. And the second people he jailed were judges who had decided cases were standing in his way of being a dictator. He was elected, but that wasn't enough, right? And God bless my old law firm where I worked for 30 years. They leaped into action for free to try to help get some of those Turkish judges out of jail with limited success. But more important, some Turkish judges were lucky enough to be out of the country at the time. There were a couple of them at Harvard studying for mid-career advancement or something. And so my old law firm, for free, helped them with their asylum petitions because they couldn't go back, helped get their families out, their parents, their kids, their spouses out of Turkey with the help of the US government. And that's one of the great things about lawyers, not judges, but lawyers. Lawyers do things like that for free to make sure the rule of law is governing wherever we can make it govern, even in Turkey in a dictatorship with a president who's putting judges in jail and lots of other people, journalists and a lot of other people who stood in his way. So the folks in Brown versus Board of Education, they find some lawyers. One of those lawyers, none of those lawyers are fired or shot or sent to Siberia. One of those lawyers, 20 years later, is appointed to the U.S. Supreme Court. His name is Thurgood Marshall. He was one of their lawyers. And that's like the reverse of sending a lawyer off to Siberia, right? 20 years later, you name him in the Supreme Court. And so the judge in Topeka says, I think that's right. You know, you tell me about Plessy versus Ferguson. The Supreme Court did say in 1890 whatever that separate is okay as long as it's equal, but I'm not sure this is equal. I hear the evidence about those schools versus these schools, and these are old buildings and these are newer buildings, and these got books that haven't been turned over for 15 years, and the white kids got the new books, and so I'm not sure they are equal. So I'm going to say it's unconstitutional. You've got to integrate your school system. The government appeals, goes up to the appeals court, loses, goes up to the U.S. Supreme Court, Brown versus Board of Education. The Supreme Court says, again, deciding a very narrow dispute, some parents in Topeka versus the school board in Topeka, and says, you got to integrate your schools. Equal protection requires that. The rule of law requires that. And so again, the handwriting's on the wall, and well, other school districts decide, we can see what's going to happen. A lot of them drag their feet, and there's got to be a lot of follow-up litigation. The Supreme Court's next case, I think, involved public swimming pools, where some town somewhere in the South said, well, you said we had to integrate our schools, but you didn't talk about swimming pools, you know? And so the Supreme Court said, when we said separate is inherently unequal, we meant swimming pools too, okay? And more seriously, in some other places, parents pulled the white kids out of those integrated schools, set up private academies, they called them, all white academies, and then the school board in those towns would support those academies with money and teachers and books. And so people had to sue again and get to the Supreme Court, which said, again, well, you can call them private schools if you want, but if the government's money is supporting them, they're not private schools. If you want to pull your kids out and put it wherever you want, okay, but you can't have government funding that, because the government can't do that. The Constitution says the government's got to treat everyone equally. So there's all that follow-up litigation. But eventually we got to the point where most schools are, at least by law, integrated. Yes, sir.
Do you have to walk up the ladder of judicial judges? In other words, you couldn't go directly to the Supreme Court.
That's right.
Okay, you got to go 1, 2, 3.
Yeah, there's 3 levels of the federal system. There's the trial court, the U.S. District Court. There's 94 of them across country. Our only one is in Boston. No, we got one in Worcester and one in Boston. Then there's 13 appeals courts, regionally, by region. And then there's the U.S. Supreme Court. So it's a 3-step process in the federal side. On the state side, it is, you start with the trial court, and then you go to the appeals court, although the Supreme Judicial Court, our highest court, can reach down and say, oh, that's an interesting issue. We're going to take that one ourselves and just bypass the appeals court if it wants. Or you can ask to go straight to the Supreme Judicial Court if you're a lawyer and you think your issue is of such public interest that you should just go straight to them, because it's going there anyway. So it's a 3-step level here. And then you've got the 4th level of the U.S. Supreme Court from the Massachusetts Supreme Judicial Court, if there's a federal issue there. It doesn't happen often, but it can happen. Yes, sir.
That's what he asked. Can you become Supreme Court Justice right out of a law firm? Or you have to go through each judge level of apprenticeship before you get...
You don't. You can go straight. You can go straight from being a lawyer in a law firm. You can go straight from being a law professor. Some of the most famous Supreme Court justices in the 20th century were. Yeah, you don't have to do that. We had a guy show up for jury duty in our Superior Court in Middlesex County, which is up in Woburn, last year. To November, December, one of my colleagues looks out on the assembled possible jurors in his case in the back of the courtroom. He's going to pick 6 of them or 8 of them to be on a jury. And he looks out and he says, is that Stephen Breyer? Stephen Breyer, turns out, a justice of the U.S. Supreme Court, showed up for jury duty in Middlesex County, Massachusetts, because his last job before he became a judge was what? He was a professor at Harvard Law School. He went from there straight to be an appellate judge, at that intermediate level in the Boston. Yeah. Yeah, so he's still a legal resident of Cambridge, is Justice Breyer, and he gets a jury notice, so he shows up. Now, if you're 70 or over, which might be relevant to about 2 of you here, you don't have to be on a jury, but you don't have to claim that exemption. And Breyer decided, I'm going to go claim that exemption. So my colleague looks out and says, oh my God, right? Do I want a Supreme Court justice on my jury overlooking my every move? And it turns out he never got to him. Breyer was the next person up when they finally picked the last juror, so they didn't need to talk to him or the other people they hadn't reached yet. But I told my colleague, I said, hey, He was never a trial judge. What does he know about trials? He started at the appellate level and then went up to the Supreme Court. So you're a better trial judge than he ever was, because he never was one. So you can come from anywhere. Other Harvard professors and people from other places have been named to the Supreme Court. The Attorney General of the United States once in a while gets named to the Supreme Court. Eisenhower did that, for instance. So you can come from anywhere, as long as you got a law degree and enough experience, and you can get through that U.S. Senate confirmation process, which is more and more contentious all the time. Yes?
I'd like to get back to the bit about the white students go to one
Yeah.
school and segregation.
Mm-hmm.
We kind of experienced that in Boston when I was
Yes,
growing up.
yes.
The busing situation. And that judge was, I mean, he's passed away now and I don't remember his name.
Arthur Garrity, W. Arthur Garrity II.
Yeah,
Yes.
that was, and I remember listening to it on the radio and on TV.
Yeah.
You know, it was like right down the street from me. I grew up in white suburbia.
Uh-huh.
But I
Yeah.
remember.
Well, that's an example of how the Supreme Court doesn't really make law directly. It has to wait for its decisions in Brown versus Board of Education, 1954, to percolate down and have people drag their feet and not integrate anything until yet another lawsuit comes up. And so there was the lawsuit that ended up in front of Judge Garrity. And he finally said, the only way we're going to make the Boston schools integrate is if I issue an order. So everybody come in, school committee folks come in, send your lawyer in, and we're going to work out some schedules here about what's going to happen when, and who's going to go to school from what neighborhood and what school, where we're going to bus people. And that's how it got done. Judge Garrity did it. Ordered it done, and there was a lot of, as you remember, a lot of bad feeling about it, bad blood about it. And another case, by the way, being fought at the same time in Charlotte, North Carolina, where the issue was people like you, white kids in the suburbs. And they tried to, they went to the Supreme Court with the argument that if we just integrate the Charlotte schools, we don't have enough white kids to go around. So let's call all the cities that touch Charlotte should be one big school district. And at that, the Supreme Court said, no, wait a minute, that's going too far. We'll impose responsibility on a city to integrate its schools, but we're not going to force people, and bad enough, we have to do that. Judge Garrity to order busing. White kids bus to black neighborhoods and vice versa. We're willing to do that, but we're not willing to start ordering the busing of people from suburban Charlotte into the Charlotte schools and vice versa, because where does that end, right? So that's the Supreme Court, that's where they drew the line back in cases that followed Brown versus Board of Education. And Boston, of course, is not the only place where these fights were being fought, and it just got more publicity than most places for some reason. All right, so let me see. So the other thing I want to talk to you about, the other heartstone of the rule of law, is the idea of due process. Due process means the government can't do something to you without giving you a chance, a process in which you can tell your story, basically. So, for example, the obvious example is a criminal defendant. Under the rule of law, that criminal defendant is not going to jail until there's been a process, until he's got a lawyer, until the government has a prosecutor, and they go talk to a judge about the preliminary stuff. What evidence could go to trial? It could be seen by a jury at a trial. Should this indictment be dismissed because it was improperly issued? Because what the grand jury heard before it said, yeah, this guy probably committed a crime, let's start a prosecution. But what the grand jury heard wasn't enough to add up to a crime. You have all those preliminary things in which a judge decides those issues. And then ultimately, if the prosecutor and the defense and the defendant don't reach a plea bargain that a judge has to approve, then there's going to be a trial in front of a jury of 12 randomly selected citizens of the county. And that's a lot of process. Nobody's going to jail in this country until they've been through all of that. And that's what due process is all about. In many countries, as we've seen recently, that's not how it works. You get accused of a crime, you get sent to jail. Some government official knocks on your door some night and takes you off to jail. There's a WNBA player now in prison in Russia right now because of some vague charge about some vaping thing in her luggage at an airport. She's been in jail for 3 months in that country, hasn't seen a judge, hasn't seen a lawyer, I don't think, barely is able to talk to the American embassy because the Russians are mad at Americans. Well, I speculate. I don't know what really happened there. But one suspects, certainly she didn't get the benefits of any process, due or otherwise, before they tossed her in jail, and she's been there for 3 or 4 months now. And Lord knows how long she'll stay. And of course, we see that all the time when American citizens get arrested in places that might want to do a hostage exchange for their terrorist or something. That's what we don't do in America. We have all that process for people before they go to jail. If they're going to go to jail, you, the citizens of this county, could say, no, we're going to acquit him. We can't unanimously agree beyond a reasonable doubt that this person did this crime, and so you can't send him to jail. And that applies not just to things where a lot is at stake, like jail time, or in some countries, of course, some states in this country, death is on the line in a murder case, right? People can get executed. They're entitled to a lot of process before that happens. But it's anything time the government's going to do something to you, you're entitled to some form of process, the Supreme Court has said. Depending on what the thing is that's going to happen to you, that will govern what kind of process you get. And so, for instance, if the Registry of Motor Vehicles suspends your driver's license because you caused a big accident, you're a menace on the roads, and you disagree, you can go to the Registry of Motor Vehicles and say, no, I want some process. I'm entitled to a hearing about the suspension of my driver's license. Now, you're not going to get a jury. You're going to get a hearing officer employed by the Registry of Motor Vehicles, but you're going to have a little mini trial before him. You can bring a lawyer if you want. I think most people don't. And you can go and talk to this hearing officer and say, I didn't do that. I'm not a menace on the roads. Here's my photographs of the accident scene. Here's my diagrams. Here's what happened. I'm going to call in this guy who was walking by at the time, and he'll tell you what he saw. And then that hearing officer makes a decision. That's the process you get for something less serious, like I guess it is serious to lose your driver's license. And because those aren't judges, those are just employees of the Registry of Motor Vehicles who are charged, have ethical responsibilities as hearing officers to follow the rule of law, but they're not judges. And so those people who lose their licenses or have any, the people who lose their jobs. I've got a case in front of me right now. A police officer lost his job, he says, because he supported the wrong candidate in the last mayoral election. And he got fired on trumped up bases later on. So he had a hearing before a state body called the Civil Service Commission. And the Civil Service Commission, again, you go there, you're talking to a state agency employee who hears everything you have to say. He did bring a lawyer to that, of course. And ultimately, the Civil Service Commission says, I'm sorry, but you were in your first year, and the law says in your first year of employment, they can fire you for no reason at all, so you're out of luck. We're not going to send you back on the force. So either of those guys, that police officer or the guy who lost his driver's license, because the decision being made by a state employee, not a judge, they have a right to come to appeal to a court. And so I've got that police officer's case right now. I heard arguments from his lawyer and the Civil Service Commission's lawyer and the police department's lawyer about a month ago, and I'm working on that decision right now. You don't get a do-over. If you've had that kind of hearing, my job, any judge's job, is simply to say, did the hearing officer, hearing examiner, whatever they're called, get it right? Did he make a mistake about the law? For instance, this issue about if you're a probationary employee in your first year as a police officer, they can fire you for any reason. That's what the law says the Civil Service Commission decision. So I've got to go make sure that is what the law says. And if not, I got to look hard at what they did and maybe overturn it. So they don't get a do-over. They get to point out to me mistakes they think happened at that hearing. And was there sufficient evidence in the record to result in the decision that was issued? For instance, if the guy lost his driver's license despite the fact that every piece of evidence in front of that hearing officer said he didn't cause that accident, he's not a hazard to navigation out there on the roads, he's entitled to come to a judge and say that. Look at the record. There's no evidence to support this, not substantial evidence, that's the legal phrase. So overturn the decision, give me back my driver's license. And our fear is, the reason you get to go to a judge is because suppose that hearing examiner is just trying to pull people's licenses because his bosses will be happy with his statistics. That could be going on. Suppose he went to high school with this guy and thinks that the guy stole his girlfriend 20 years ago, right? Now he's going to get him back by pulling his driver's license. We're worried about that sort of thing happening. We don't trust people who aren't judges to not do those things. Of course, they, I think, rarely, if ever, do those things. But that's why there's this layer of protection. You can go to a judge because the judge applies the rule of law and has been doing it longer and more seriously than those hearing officers. So those are the two kind of core principles that I wanted to talk about that really, that at the heart of the rule of law, that make this, that make it, if everyone is treated equally and everyone's entitled to some process, the amount depending on how serious the penalty is, and a judge gets to look at all that and make these decisions. That's really at the heart of the rule of law. And so I'll just end my remarks by saying, you know by now that I am a firm believer that we live in the best country in the world. And one of the reasons we live in the best country in the world is because John Adams was right. He and his friends back in the 1770s, 1780s, when they were designing this country and how it was going to function, that they said we were going to be a government of laws, not of men. They learned from that example of George III and being that man who was ruling. And all of that has survived for 240 years or whatever it's been now, with the judiciary there as the backstop. The judiciary there to say, no, you got to treat those people in those schools equally. No, Mr. President, I know you're the president, but you got to bring us some proof before we're going to overturn an election. With a judge who's not going to say to the famous actress or the rich guy, oh, you're rich and famous, and so we're not going to prosecute you. We're not going to send you to jail for bribing your daughter's way into Stanford or whatever. So that's what makes this, the rule of law is the most important thing here, and that judges are here to enforce it. That's the safeguard. And so that's why I'm proud to do what I do. I like being a lawyer a lot, but this is better because my job is to do justice. What better thing to be able to say, right, to do for a living than justice? So I love this job. I love this country. And it's because we're governed by the rule of law. And let me stop there and ask you if you have any other questions about anything. Yes, ma'am.
Yes, I'd like you to explain when a person that commits a crime makes a plea.
Yeah.
And they plead, say, not guilty, and we know they're guilty. Why is it that, I guess a better way to say it is, why is it that whatever crime they commit, whether it's been filmed and we know they did it, and they plead not guilty, how is that possible?
Well,
What
at the
is
beginning,
that?
when the charge is brought, the grand jury indicts the person, or in the district court, there's a criminal complaint by a police officer. Now the person's charged with a crime. And the first thing that happens is he gets arraigned. He goes in before a judge, and the judge says, how do you plead? And he always says not guilty, because why plead guilty right then? Why? You got to wait and see how much evidence the government has, because even if it's on film, who knows if there's some problem with the film? Who knows what a good, whether that's going to be enough? Who knows if there's an explanation for what's shown on the film that's not this person committing a crime, it's this person rushing to the defense of somebody who someone else is robbing or something. So you always say not guilty. And then there's a process in which the defense lawyer tries to figure out, the prosecutor has to give the defense attorney the evidence. Here's what we know. Here's how we're going to send your guy away. And the defense lawyer makes some judgments about how strong the government's case is. And of course, the client, the defendant himself, I say himself because statistically it's usually a man, not always. He gets the final decision, but he's got the advice of a good defense lawyer, hopefully a good defense lawyer, who says, I know we pleaded not guilty, but if this goes to trial, a jury's going to find you guilty in about 10 minutes. And then we've lost all control, because at that point, if a jury finds you guilty, we go before a judge the week after, and he decides what the sentence is. And we have no input. If we make a deal, now that we know what the evidence is, how strong the case is, maybe we're going to make a deal and talk to the prosecutor about, if the judge might give you 5 years for this, how about we agree to 3? And if they can get an agreement from the prosecutor, then the two lawyers and the defendant come to a judge who ultimately is the only person who can sentence anybody to anything. And the judge has to say, based on the strength of the case, the nature of the crime, the criminal record of the defendant, 3 sounds okay to me. So if you plead guilty, I will sentence you to 3 years. That's how it works.
Just another little question I have about that. Okay, so a person goes to trial and they present both sides and they decide that the person is not guilty by reason of insanity. I want to know, why can't they be guilty by by reason of insanity.
Well, you can't be guilty unless you understood what you were doing and you knew it was wrong. That's the definition of guilt in the American criminal justice system. You can have done it without knowing it's wrong because you don't have the mental capacity. And so that's why we call it not guilty by reason of insanity. But that doesn't mean that person is out on the street. Then there's an evaluation done by professionals, mental health professionals, who then come to the judge and say, this person is a menace to himself or a menace to society. And so let's put him not in a prison, but in a mental institution and give him some treatment. And maybe someday he won't be dangerous anymore and we can release him. So those people don't go out on the street unless a judge has decided that they're not really dangerous to anybody else.
My only problem is that today, there are no mental institutions. Or there are very few, but there are no beds.
There are, the state has, the Department of Mental Health runs institutions just for people like this. And they can always, insanity defenses are very rare. There aren't that many people out there. I've seen 2 maybe in 9 years as a judge. Now, as part of that, I only do criminal stuff about half the time. So say 4 years, I've seen 2 of them. They're not that common, and you can always find a bed for somebody like that in the Department of Mental Health in a secure institution. Sir.
Wasn't some talk some time ago the verdict would be guilty but insane?
Mm-hmm.
Innocent but insane.
Yeah, I'm not sure exactly what we say. I think we say not guilty by reason of a mental, it's not defect. There's a word like that.
The word was guilty but insane.
Yeah.
It's the same.
Yeah, it's the same result, but I think it's an important distinction. The criminal laws say, well, the idea of criminal justice is that you should be punished for a crime that you knew you were committing. And so if for some reason you didn't have the mental capacity to understand that you were acting wrongly and violating somebody else's, I don't know, by hitting somebody, by raping somebody, whatever it is, if you're too mentally ill to understand that that's wrong, I think it's right to say, it would be wrong to say guilty. Maybe not guilty is the wrong phrase. Maybe it should be something like undecided because this person doesn't have the mental capacity we've decided. A judge has decided.
Deeply performed, so they're guilty of doing it.
Yeah, that's right.
Like if I could hit you right now, I'd be guilty, but I might be crazy to do it. Right? I'd be guilty.
Yeah, but there are circumstances where you assault somebody, you commit assault, but you're not guilty, even if you're not insane. For instance, if you are a doctor and somebody collapses in front of you, an assault, the crime of assault is an unconsented touching. And so if you leap to kneel down next to this person who just fainted and try to help him or her, you've committed assault. You're never going to be charged with it because that person was out cold and couldn't say, yes, please do those chest compressions. My heart has stopped. Please break my ribs, which happened to my brother recently when he had a heart attack. Yeah, that's an assault. It resulted in injury to my brother, broken ribs, but it also saved his life. And so so that person didn't have, that doctor, that EMT, didn't have the intent to commit the crime. Knew it would be wrong to start pounding on my brother's chest if he wasn't in the middle of a heart attack, but also knew that this is what I got to do and he'd want me to do it. And so he's committed a crime, but he's not guilty of that crime because...
That's very interesting.
Yeah.
Retired RNs.
Yeah. So you've probably committed lots of the crime of assault. You've committed it lots of times, but...
Airplane.
Yeah, right. There you go.
You're on an airplane.
Yes, ma'am.
What happens if you as a judge, okay, people come before you and they've set up a plea bargain,
Mm-hmm.
and you as the judge say, what happens if you say, no, that's not an appropriate?
What happens is the person cannot plead guilty without the judge saying, what the judge said. What I say is, no, I don't think that's enough. I've looked at this person's record. I've looked at the circumstances of this offense, and I'm not going to sentence him to 3 years. I don't care if the 2 lawyers agree. I would sentence him to 5 years if you wanted to plead guilty and accept a 5-year prison term, and then that puts the ball back in their court, and they've got to decide. The defendant has to decide: do I want to take the 5 years, or do I want to say the deal's off? Let's go to trial and see what a jury does. Maybe the jury will acquit me. And maybe the judge, once he's heard all of this in a trial, heard from all the witnesses, maybe he'll think 3 years is okay. Or maybe I'll get another judge at trial who will feel differently. Although we are very careful about that. Since we do rotate from courtroom to courtroom and county to county, we will never even talk about a plea bargain with the lawyers for the defendant and the government unless we first check and see, were you here 3 months ago in front of Judge Kazanjian, and did she say 3 years? Well, don't come to me and ask for 2, because unless you can convince me that she was wrong for some reason, there's a new fact or something, I'm going to respect her recommendation. Because there's an opportunity, given that we go from county to county, to play games like that. So we try very carefully to avoid that. But you might get a different judge at trial who sees the evidence and ends up now knowing much more about the crime than I did, just hearing from the lawyers about it and reading the police reports and things like that. So that judge may say after the trial, oh, maybe, this is not really a 5-year thing. Maybe it was a 3-year thing. And so maybe you go to trial, you get convicted, and you get 3 years anyway. It seems unlikely because most of us have a pretty good idea of what the market rate is, I guess, for a particular crime, how many years is appropriate for a particular crime. But we don't always agree, and sometimes a judge will know more than I after a trial. Yes?
Sorry, but I just wanted to know, what is your take on these live trials that you see on TV? I mean, not the Judge Judy's and
Yeah, the real trials. Right, Derek Chauvin, right? Yeah, people. Well, we are a government what we're doing is your work. And so certainly it seems to me you can go into a courtroom. Anybody can walk off the street into the courtroom. The public can do that. That's part of, that's a First Amendment right of the public to go observe its government in action. And so now in the modern era, why not do that as well? Let people watch who can't get to the courthouse because there are trials in Minnesota and we're in Massachusetts. I got to be a YouTube sensation for a brief time in the summer of 2020. Oh, and this actually answers another question somebody asked earlier about, can you start at the top at the Supreme Court? The legislature in 2020, early in the pandemic, passed an eviction moratorium. It said landlords cannot evict tenants who aren't paying their rent because of the pandemic under certain circumstances. And the landlord lobby got together and said, wait a minute, that's not right. They can't do that. We've got constitutional rights here to own and use our real property as we see fit. And so we're going to file a lawsuit. So they filed a lawsuit in the state Supreme Court saying, toss out this statute. If our tenants don't pay rent, we don't care why, we have right to evict them if we want. And so they went straight to the state Supreme Court, which said, interesting. You found some quirk in the state constitution that says we could take this. You could start here if you want, but we think we'd rather have like a trial court judge look at this question with the benefit of all the evidence you want to present, and then we want a trial court judge to issue a decision, and then we'll do what appeals judges do. We'll decide whether he was right or not. So they sent it back to the Superior Court. And they said, specially assigned it to a judge, and the chief judge picked me. And so I got to decide this case, and it was of such public interest that we not only set up our usual Zoom thing what people can watch if they get the Zoom invitation, we put it on YouTube. And so people could watch this hearing. It was a two and a half hour hearing, lots of interesting issues. And so I said, thank you, take it under advisement, and then I wrote a decision a month later that said, no, the legislature can do this in light of the public health crisis. And then at the Boston College Law School Christmas party, that 6 months later, I teach in my spare time at Boston College Law School. I go to the Christmas party, and this lawyer comes up to me and says, you're the guy from the eviction moratorium case. I watched that on YouTube. That was fun. And I thought, ooh, I was a star. Briefly, very briefly. But I mean, the idea is that people should be able to watch us do the people's business. And so I'm all in favor of that. The U.S. Supreme Court only in the pandemic started allowing the broadcast of the audio of their arguments. And I don't think they don't allow the video yet, although what's to see, right? It's 2 lawyers in front of 9 people up there, right? Not that exciting to see. But it took a pandemic to make them think, oh, nobody's coming into our courtroom, and so how can we say we're doing the people's work here unless we actually allow the audio to be broadcast? So you can listen to the U.S. Supreme Court now. Other questions? Yes, sir.
When a person looking for a plea bargain, they want to lower
Yeah. Yeah.
plead guilty.
Yep.
Why is it that the defense and the prosecution attorneys don't fight for changing the plea, number of years to go to jail, but they have to go back and get a trial? In other words, it's like I'm guilty is rescinded. Okay, so you're starting back from scratch. Why isn't the person guilty?
Because
They pled guilty.
no, they didn't. Because when they go to the judge, they say, I would plead guilty if you would give me this many years.
I'm sorry.
Yeah, so they don't actually,
Understand.
yeah, we don't actually let them plead guilty. In fact, before anybody pleads guilty, we have a 20-minute conversation with them in which we, first of all, tell them about all the rights they're giving up by pleading guilty, the right to a trial by jury, 12 citizens picked at random to decide your fate, unanimous, beyond a reasonable doubt. You're giving all that up. You understand that, sir? And then we tell them, here's the facts alleged. This is what the police report says. This is what the indictment says. Did you do these things? And if I'm not satisfied, A, that the person understands what he's giving up, and B, that he's willing to accept responsibility by saying, yeah, I did those things, I'm not going to accept the guilty plea. I'm going to say, sorry, yeah, you haven't satisfied me that you really believe that you're guilty. If you're just doing this because you're worried that a jury might find you guilty and somebody might give you 10 years, well, that's a risk you're going to make. You either tell me you did these things or not. I'm not going to take a guilty plea from somebody who denies he did these things. But on the other hand, he doesn't have to plead. He can't plead guilty until we've had that 20-minute conversation. And I'm satisfied that he understands what he's doing, understands what he's giving up. He did these things, and that this, and more importantly, that this sentence that they've agreed on and I've accepted is in fact justice. Then he says, I plead guilty, and then the clerk says, okay, 2-3 years or wherever. And then that's the plea and then the sentence.
Actually not pleading guilty.
Right,
So there's a deal.
right. A deal approved by the judge. They're offering to plead guilty. And they could be doing that even if sometimes they say, I didn't really do that, but I'm worried about what happens if I go to a jury there and they find I did it. And so we have to get past that if, in fact, we all get to the point where we agree on a sentence. He has to say, yeah, I did it. I did these things. And now I'm going to plead guilty. And then the next thing is the clerk saying, okay, you're hereby sentenced. The judge sentences you to 5 years, to 3 years, or whatever.
Wouldn't it be nice if it only took an hour for you to do all this?
Yeah, it would. It would. But it's, yeah.
When I worked in the ER here in Natick, I had to take the SEDNAP course, 3 months for the emergency that the state had put on.
Mm-hmm.
And I never had a problem smiling or being friendly, but it just stuck in my mind when the judge or the lawyer rather, that spoke to one of our classes said, remember this, if you walk into someone's room, announce yourself who you are, and put a smile on your face. You won't get sued as quickly. I said, oh my God, I'm in the wrong group.
And did you ever get sued?
No. Not yet.
And by the way, I didn't see you at Fenway Park last night where it was nurses' night at Fenway Park.
I know.
Yeah, it was. Lots of nurses at Fenway Park. Oh, they were going in buses. The Lawrence General Hospital nurses had their own bus coming in and matching T-shirts, and yeah. Next year.
Godspeed.
Yeah. And next year, maybe we'll get another 2-hit complete game from our pitcher, which was a pleasant surprise last night. All right, well, my time is up. So I thank you very much for showing up, for caring about these sorts of issues enough to come. I hope you've learned a little bit, and it's a pleasure to be your employee. Thank you.